Instant reaction. Some crazy quotes are flowing out of the courthouse in Charlotte, North Carolina. NASCAR and their attorneys met with 2311 Front Row and their attorneys in front of a judge to argue the team's latest preliminary injunction request.
NASCAR just got hit with a big surprise in court, and it came from its own teams. 2311 Racing and Front Row Motorsports stood up to the league, and when NASCAR tried to fight back, the judge shut it down. This could change everything about how the sport works. So what really happened? And what does it mean for the future of racing? The story begins when 2311 Racing and Front Row Motorsports refused to sign the new charter agreement offered by NASCAR ahead of the 2025 season. The charter system is huge. It guarantees race entries, revenue shares, and a seat at the table in what is billed as the sport's top-tier stock car racing series in the United States. The two teams accuse NASCAR of monopolistic behavior, saying the charter model locks them into unfair terms and limits their ability to truly compete. Their move forced a dramatic clash. The teams filed an antitrust lawsuit against NASCAR in October 2024. They argued that NASCAR's control over charters, revenue distribution, and race guarantees creates an unlevel playing field. In March 2025, NASCAR didn't just defend, they went on offense. The league filed a counterclaim, accusing the teams of colluding. NASCAR alleged that 2311 Front Row and co-owner Curtis Polk executed a strategy to threaten, coerce, and extort NASCAR into meeting their demands for better contract and financial terms. NASCAR called the two teams an illegal cartel, saying they coordinated boycotts of the Team Owners Council meeting, interfered with the league's broadcast negotiations, and negotiated as a group when each team should have been negotiating separately. The stakes skyrocketed. NASCAR sought triple damages and even threatened to remove guaranteed starting spots from the teams if they continued to challenge the charter system. It sounded like a power move, but it also set the stage for a major legal test of how the sport is organized. Then came the bombshell. On October 28-29, 2025, U.S. District Judge Kenneth D. Bell granted summary judgment in favor of the teams, dismissing NASCAR's counterclaim. Why? Because NASCAR failed to prove two essential things: an unreasonable restraint of trade and a so-called antitrust injury to competition. The judge wrote, "Even assuming that the joint negotiations NASCAR challenges caused economic harm, that does not equate to a harm to competition. Rather, NASCAR getting more or less in contract negotiations is simply that, a hit to its bottom line, not competition." The court noted that individual negotiations were available and regularly used by NASCAR, so the idea that 2311 and Front Row had acted as a cartel to shut out competition didn't hold up. That decision weakens NASCAR's ability to claim antitrust violations in such contexts. It doesn't end the case, but it marks a major turning point. The responses came quickly. Attorney Jeffrey Kessler, representing 2311 Racing and Front Row, called the ruling a vindication. He said the teams remain fully committed to a system that is fairer for drivers, employees, partners, and fans. NASCAR, meanwhile, said it respects the court's decision, though it respectfully disagrees with its legal reasoning. It confirmed that if resolution is not reached, it intends to appeal. Behind the scenes, the dispute had already reached mediation stages. Judge Bell himself is overseeing the mediation process ahead of the December 1 trial date with the same parties. For NASCAR, this is a shot across the bow. For the teams, it's a boost of momentum. For everyone watching, the business of racing just got a lot more interesting. The drama isn't simply legal. It has major implications for how this sport is governed, how power is distributed, and how competition is structured. The charter system underpins NASCAR's model. It guarantees revenue shares, race entries, and stability for teams. If two of the prominent challengers, one co-owned by NBA legend Michael Jordan and NASCAR driver Denny Hamlin, push back and win a major motion, what does that say about the system? It raises questions. Are charters too rigid? Do teams have enough say in negotiations? Can a league so tightly controlled be challenged by its own members? The ruling undercuts the idea that group negotiation by teams automatically violates antitrust law when the governing body still negotiates individually. For fans, this might alter which teams thrive, how deep pockets play in the sport, and who gets access to the big prize payouts. For sponsors and partners, it might mean the structure of deals and rights shifts. The ripple effects could reach far beyond the track. On top of the legal stakes, This case highlights a deeper issue inside NASCAR: how much say the teams actually have in shaping the future of the sport. For years, NASCAR has held most of the control, with teams expected to follow suit. But this lawsuit, and especially the counterclaim dismissal, proves that the power dynamic is shifting. Teams are realizing they have more leverage than before. They're more organized, more vocal, and they're willing to take risks. The days of silently going along with decisions from the top may be fading fast. This fight also shines a light on the role of ownership and influence. With Michael Jordan involved in 2311, the spotlight on this battle got even brighter. He's not just a name, he's a business strategist who understands the importance of fair deals and long-term equity. And when you combine his mindset with Denny Hamlin's deep racing roots, you get a team ready to shake things up. Front Row Motorsports, often seen as a smaller operation, stepped up too. Their alliance with 2311 shows that this isn't just about the big teams versus NASCAR, it's about everyone wanting a better future. There's also the business side of the sport to consider. NASCAR's model has long relied on sponsor loyalty, TV deals, and event ticketing. But if teams feel boxed out of key negotiations, they may start to pull back or shift their strategies. Teams may begin exploring other business models such as private equity backing or even competing series if conditions don't improve. The lawsuit highlights not just a fight for fairness but for future-proofing racing as a sustainable business. In an era when entertainment options are endless, sports have to evolve to stay relevant, and that includes how they treat their teams. Another layer in this legal battle is fan loyalty and perception. NASCAR thrives on its connection to loyal fan bases and regional pride. If fans begin to perceive that the sport is being unfair to its teams or punishing those who speak out, they may turn away or demand change themselves. Social media has made it easier than ever for fans to rally around teams or causes they believe in. This case could fuel more fan engagement, but it could also spark deeper criticism of how the league is run. NASCAR needs to be careful not just about winning in court, but about winning in public opinion. Fans might not think these courtroom battles affect them, but they do. The outcome could change how races are scheduled, how many cars compete, and how prize money is shared. That could determine which teams stay alive and which struggle to survive. If the charter system is forced to change, it might become easier for new teams to enter the sport or harder, depending on what replaces it. Either way, fans should pay attention, because this case could shape the NASCAR they watch for years to come. The trial is still scheduled for December 1, 2025, in federal court in Charlotte, North Carolina. The team's original antitrust case against NASCAR remains alive. The counterclaim may be dismissed, but the core dispute is far from over. If the teams prevail in the trial, it could prompt wholesale changes in the charter system, revenue sharing, and team league governance. That could open doors for teams to renegotiate how they operate and how much control they have. If NASCAR prevails, it could reaffirm its authority and the charter model's durability, but with a legal scar from the counterclaim dismissal. Either way, the internal dynamics of this sport are shifting, and for fans watching the drama unfold, it means the races might look the same on the surface but off track. The rules of the game could be completely different next season. Here's what we've learned. Two teams dared to challenge the system. NASCAR fired back with claims of cartel-like behavior. The court said, "Not so fast, economic harm to a league is not the same as harm to competition." That ruling marks a major win for the teams and a significant legal setback for NASCAR. But the fight isn't over. The core lawsuit still looms, and the implications stretch into how this sport is managed, financed, and evolved. Whether you live for the roar of engines or you're just intrigued by business battles behind the scenes, keep your eyes on this story. Because the finish line isn't a checkered flag, it's a legal decision that could change everything.